off and running. Well, thanks again for being with us. And we are going to get started because we are also recording this.
Okay, great.
So folks who are not able to join or who join while you're in progress can watch whatever they missed. But I know that everybody's time is precious. So since we're at 4:30, I'm going to go ahead and get started. And just want to welcome everybody, the North Carolina the Commission on the Future of North Carolina Elections. We have Paul Cox, who's going to be speaking to us today to give us an update. We know that there have been a lot of laws in North Carolina that have been proposed around elections. Some have passed, some are under appeal, some are in force. And Paul Cox is the General Counsel for the North Carolina State Board of Elections. Many years of experience working with elections, and he has given this presentation to some election directors and some other folks. So he's watching the legislation carefully, and it's going to give us an update to help inform our work on the Election Commission with looking at how things are administered now, and then what might be best practices going into the future, what legislation is pending that we might see, even as we're doing our work this year, with a full report to come at the end of 2024. So with that, I'm going to turn it over to you, Paul. Thanks for
Okay,
joining us.
of course, and I'm glad to do it, and happy to see you all. I think the work you do is very important, and I'm glad that Jennifer and Bob and others have engaged us at the state board to assist you as you're working through North Carolina election processes and North Carolina election law. I'm going to try to share my screen now, and as promised, provide and can you tell me, Jennifer, are you seeing the screen as it's supposed to appear, or are you seeing my
I'm
slideshow with the
Yeah,
presenter?
I'm seeing the presenter view so that
Okay,
we
let
can
me see if I
see,
can
your
swap it.
next slide, etc. So I think
How
if you
about
go
that?
to slideshow, there you go.
All
That's
right.
it. Now we
I
got
just
it.
had to swap my screens. I finally figured out how to do things like that after having done this many times. But as Jennifer had mentioned, I'm sort of recycling a presentation I just gave last week to the statewide training conference for election officials in North Carolina. The State Board of Elections has a statutory mandate to provide these training conferences to election officials throughout North Carolina. We do one in a municipal election year, and we do two in a general election year, statewide general election year, one before the primary and one before the general election. So the one I gave, this is very timely because it was literally last week in Concord. We had representatives from most of the county boards of elections at the conference. Whoops, it's starting on its own now. It's telling me I need to go ahead and move, I guess. Let me go ahead and start off with the presentation. The reason we do this, and I'll go through these really quickly, is because the county board members take an oath to follow the law, the election laws of North Carolina, and it's imposed upon them on statute that the duties that the statutes and the new laws impose upon them are requirements of the job, and so we reiterate that whenever we're giving them a sort of refresher on what the election laws are. I'll go through real quickly where this presentation is going to go. New election laws is going to be sort of the start off. I'll go briefly on some court cases because as things are going, really the newness of the election laws is probably the most important thing that's happening right now. But the court cases are important, and there are some that we need to monitor. The state board has also issued some rules, promulgated some rules is the right way to say it, who have been approved by the Rules Review Commission. It's actually about to meet Thursday to consider some additional rules, so I'll go through some of those, and then I'll wrap up with some resources that I'll leave you with if you need to consult them. And I think that Jennifer's made this and Rachel made this available to the commission members. Certainly, if you have any other questions, you're welcome to reach out to us. So starting off with new election laws, Senate Bill 747 was the big change. They called it an omnibus election bill for a good reason. I mean, there was a ton of changes to election processes in North Carolina in Senate Bill 747, which was enacted last fall. It changed how we manage primaries in certain ways, really around the edges. Early voting it's a new species of voting. It used to be called one-stop absentee voting, but now it's called early voting. It's its own thing. It is not a species of absentee voting anymore, and it has its own section of the code now. Same-day registration, an aspect of early voting is when you can register during early voting. That process has changed somewhat, and we'll talk about that a little bit. Election observers, these are the folks that get appointed by the political parties. In some occasions, if you got an unaffiliated candidate that gets on the ballot through a petition, they can also appoint an observer. The rules regarding observers have changed pretty significantly. One of the biggest voter-facing changes is the absentee deadline for getting your ballots to the County Board of Elections on election day. There's no longer, you get it in the mail on election day, it gets postmarked, and it can still arrive 3 days later, as long as it was postmarked by election day. That's no longer the law. You got to get it into the office on election day by 7:30 p.m., just like when the polls close. We'll talk a little bit more about that and some changes to absentee laws. There's requirements now for county boards and state board to retain election records a little bit longer, really an internal administrative item. There's no limitations now on the use of private funds, donations, and even in-kind contributions from non-governmental sources for election administration. I'll talk a little bit about that. A change to how we certify certain municipal elections, particularly when they cross county lines, and then some changes to our list maintenance practices. Here are the primary law changes. One is that unaffiliated voters can now participate in any party's primary. It used to be the case that the parties were given the choice. Are you going to allow unaffiliated voters to participate in your primary? Now the law is that any political party has to allow unaffiliated voters to participate in their primary. It used to be the case that the Democratic and Republican parties always, well, in recent years, have allowed unaffiliated participation in the primaries. Now, so in practice, what this law has changed is that now the minor parties are required to do that. So that's one change. The other change is one that we asked for as election administrators, which was, we have this second primary possibility. If you don't get a winner outright because they don't get what's called a substantial plurality in the first primary, a substantial plurality is over 30% of the vote. If it's a one person gets the nominee. If it's not over 30% of the vote, then the next vote earner can request a second primary. And it used to be the case that the second primary was either 7 weeks after the first primary or 10 weeks, depending on whether it was a state or county contest or a federal contest. The federal contest had to go 10 weeks later because of some deadlines in federal law for getting ballots out. If it was a state or local race, then it would be 7 weeks later, which was maddening to election officials. So we've finally got that narrowed down to just 10 weeks after the first primary, regardless of what kind of contest it is. Early voting, don't call it one stop. As I said, it's no longer one stop absentee voting. It is early voting. One of the biggest changes in that shift is that county boards of elections are now appointing early voting officials. It doesn't happen at every early voting site if it's the actual county board office. That's handled administratively, I think, because the legislature considered that to be more of an office function and didn't want to have those folks appointed and have the political parties involved in recommending, administrative staff for staffing that site. But if it's not the County Board of Elections office for early voting, the county board is now appointing the early voting officials as chief judges and judges of election, just like on election day. The political parties get to recommend names and the county board members appoint from those lists that the political parties provide. Another big change with the move from one-stop absentee voting to early voting is that it changes the challenge process, the voter challenge process. So it used to be the absentee ballots, whether it's early voting absentee ballot or an absentee ballot in the mail, you could challenge that sort of the same way, the same rules applied. Well, this is no longer absentee voting, early voting. And so you have to actually challenge a voter. If you're going to challenge a voter, you have to challenge them in person while they're voting, just like you would do an in-person voter on election day. There's no, waiting around and providing the challenge later on, like on election day at the county board office. So the challenges happen in person. One change is that who can challenge has been broadened to any county voter. Used to be the case that for absentee ballots, you could only challenge a ballot for an absentee voter if you were a voter in the same precinct, which is quite limiting. That's broadened to any county voter now can challenge another county voter's ballot. This is the last one sounds very in the weeds. The county boards can't run early voting tabulation before the close of the polls on election day. That's actually really significant for county boards of election, and it's going to be really significant for when results get released on election night. Because it used to be the case, because early voting was a type of absentee voting, county boards hold an absentee ballot meeting on election day before the polls close in the afternoon, sometimes as early as 2 p.m. The default is at 5 p.m., but in any event, they were accustomed to running their early voting tabulators. We call it closing the polls, which means your tabulation tape runs and you get the actual results. And you can have those at the ready, keyed up into your computer. And when the polls close at 7:30 p.m., they were able to just hit send and it would go to that election night reporting site. Because of this change in the law, they can't do that. They won't be ready to pop results up from early voting right away. So it used to be the case when polls closed in North Carolina, you could immediately get 40, 50% sometimes of the votes that have already been cast and tabulated right when the polls closed. That's not going to be the case anymore because the county boards at 7:30 are then going to have to run the tabulation from those early voting machines, which takes about an hour to do, honestly. So that's going to be a pretty significant change in what the public sees, because there's going to be a delay until 8:30 or so before you see a significant number of early voting totals be placed onto the election night reporting. Same day registration, I mentioned this. Same day registration is if you miss the regular voter registration deadline of 25 days before an election, you can register to vote at an early voting site and vote at the same time. Now, you have to provide a document that shows proof of residency to do that, a utility bill, bank statement, a governmental ID, other government document. It has to have your current address on it to prove that you are the resident where you say you are. So you have to provide a bit more documentation than you would if you're regularly registering before the deadline. But so this it's a similar process as it was before. So the process itself hasn't changed significantly. There are some slight differences in the types of documents that need to be provided. The state board put out a numbered memo. We call these, these are the guidance documents we put out to our administrators in the county level to explain how to manage this process. It talks about just those differences in documents and what documents are required to prove address. Like I said, it's sort of differences around the edges. It's not dramatic differences in the documents that you use to prove residence at the polls. The big change is there's now a single mail verification. So whenever you register to vote, the County Board of Elections is going to send out your voter registration card in the mail. That serves a dual purpose. One is to provide you your information about your voter registration, all of your voting jurisdictions, what congressional district you're in and all that. But it also serves the purpose of verifying that you live where you say you live. If that voter registration card comes back as undeliverable, under normal circumstances, the county board is supposed to send it again, just in case there was some mistake. And if that second one comes back as undeliverable, they will not register you. Because of the time it takes to do that, the legislature changed that rule for people who same-day register and provided that only one undeliverable mail verification, in other words, undeliverable voter registration card for a same-day registrant, if it comes back to the county board, then you have to not register that person and pull their ballot from the count. In other words, they failed to prove that they live at the address they have. Now, we have litigation ongoing about this in the Middle District of North Carolina in the federal court, and the court issued a preliminary injunction deciding that you cannot pull a ballot from a voter based upon undeliverable mail if you do not provide them some sort of hearing process, some sort of notice and ability to contest that. And so we've put into place a sort of stopgap procedure to provide voters notice when this does happen. I will say that this in the highest of turnout elections will really only affect about 2,000 voters across the state. So we're not talking about a sort of dramatic change to a lot of voters' experience, but there is this additional process now. Sorry, my slides are advancing on their own. I don't know what I did to this slideshow, but we do now have this notice and cure process, and our expectation is that when the legislature comes back into this short session in April, May territory, that they are considering looking at how to codify an actual, a legislative statutory notice and cure process for these same-day registrants whose verification is undeliverable. So that's same-day registration changes in a nutshell. The other big change, one of the other big changes from 747 is observers. There's different appointment deadlines now for observers. They can be appointed the day before they're about to serve, which is a headache for administrators, getting everybody, straight who's supposed to be in the voting site. It modified the procedures where you would challenge the appointment of an observer. This is a rarely used provision in law that county boards can say, hey, we're not going to allow that person to be at our voting site an observer. Last time around they did this, this, and this. That was too much. We're not going to allow that again. So there's different procedures now for that rejection. It was previously just a summary rejection. Now there's a challenge procedure, and the observer's appointing party can be heard on that and basically have a hearing before the County Board of Elections to determine if that observer is going to be able to serve despite the objections. Similarly, there is a rarely used provision that allows for chief judges to remove an observer from a voting site if they become unruly. And that, like I said, is a rarely used, but it is used occasionally. What the new legislation provides for is an appeal process. So if an observer gets removed, they can appeal that to the County Board of Elections. The County Board hears that and can make a decision on the record. The law provided some items that are specifically allowed for observers. They can have up to 3 observers per party per site. They can listen to conversations between the voter and the election officials as long as it doesn't interfere with the privacy of the voter. They can take notes, including taking notes on an electronic device like a cell phone. They cannot take pictures though, or take video or audio recording. They can move about the voting place. This has caused some consternation among local election administrators about how they can manage the security of the voting site when you folks are moving around the voting place like this. But the legislature did provide that you can do this as long as you don't A, compromise the privacy of a voter, or B, interfere with the conduct of the election. So whenever observers moving around, the chief judge has the authority, the discretion. If one of those things is being compromised, they can say to the observer, wait a second, you can't be there because you can see a voter's ballot. That's compromising the privacy of a voter. So there is the ability to manage that process. Observers can leave and re-enter the voting site. There is previous guidance that they shouldn't be going in and out of the doors, but that is specifically allowed now. They can witness and photograph the opening and closing of the voting site. So this is when the voting equipment gets booted up, when ballots are being laid out and prepared, when the check-in station's getting set up, and then at the end of the day, on election day, it's when you close the polls and you run the tabulator and it shows the vote totals. If it's early voting, it's stopping the voting for the day. It's reconciling the number of check-ins you've had that day with the number of ballots that have been tabulated by the machine. And so those are processes that are specifically allowed to be witnessed and photographed now by observers. A lot of things that are specifically not allowed. Viewing a marked ballot, impeding voters, compromising the privacy of a voter, interfering with officials, and electioneering and making calls in the enclosure for obvious reasons, all those things. Now, what's not mentioned specifically in the new observer law are a lot of background rules that exist to protect the voting site. And, those are in various provisions in the elections laws, chapter 163, and they apply to all people in the voting site, whether they're an observer, a voter, somebody coming in to challenge, somebody who is assisting a voter when they're eligible to assist, and even election officials. There's all sorts of laws that still apply to observers that are not specifically addressed in the observer law. And that's one thing that we have to communicate to our election officials and also to the public, that there was a lot of consternation about the changes to the observer law. We want to remind people, hey, there's all sorts of things out there that forbid certain conduct. It's still illegal to interfere with a voter. It's still illegal to intimidate a voter. It's still illegal to intimidate or interfere with an election official. So all those things that exist in the background still exist and are relevant to observers. Finally, there is an allowance for the state board to require identifying badges for observers so that the voters and election officials know what that person's role is at the voting site. There's no confusion about a partisan appointed observer, being an election official, for example. The voter's going to know, oh, that's not somebody I should ask about how I cast my ballot. As somebody who's there to observe the process on behalf of a party. The state board has provided some resources. I'll just skip over this. This is more for county board consumption. Another change in 747 was the voter assistance log. There is a new requirement that for anyone entering the voting place to provide voter assistance, they'll be asked to sign this log. There's an exception for minors who are in the care of the voter, but generally there's a specific, there's a specific provision of law that allows for people to come in and assist another voter when they're entitled to that assistance. I mean, and that's the statute there on that form 163-166.8. That authorizes specific circumstances when someone can get someone to help them cast their ballot. Usually it has something to do with a disability. It could be a language proficiency issue, that sort of thing. So what the legislature's done here is now required anybody providing that sort of assistance to sign the log, so there's a record of it. I mentioned the absentee changes. I already discussed this about there's no more grace period for getting the ballot in. Has to get in by the close of polls on election day. It does not apply to, here's an acronym that maybe a few of you know, UOCAVA. UOCAVA is the federal law that applies to uniformed and overseas citizens. So North Carolinians who are in the military or military families, and North Carolinians who are living abroad. And so there's special absentee rules that apply to those type of voters under federal law. That ballot delivery deadline does not apply to them because of federal law applying here. Actually, it's not because federal law applies. It's just the legislature carved them out. There's other provisions of law that provide a later deadline for those ballots to arrive, and as long as they're postmarked correctly. And so those were carved out. The absentee law changes codified the absentee deficiency cure process. So what is that? It's something the state board put into place administratively based upon some lawsuits back in 2020, where there wasn't this process if somebody submitted their absentee ballot and there was something wrong with it, like they forgot to get one witness, or there's just a missing signature somewhere, for example. How are you going to manage a cure process for that? There wasn't before 2020 a process for the voter to be notified and given an opportunity to fix that. So administratively, we provided a memo to explain how that should happen based upon what the courts had ruled. Now that process has been codified in law. There's some modifications in what we had been doing. The legislature now specifically authorized the ability to cure any photo ID issues. Y'all remember, photo ID is now required. It's also required for absentee voting, which presents some complication, whether somebody has the ability to make a photocopy of their ID to put with their absentee ballot. So, when you get that in the mail, when the county boards receive that, if you have a problem with the photo ID, it's unreadable, or it's not the right kind of photo ID, or whatever it may be, or maybe they just forgot to put it in there. That's a deficiency that can be cured. So the voter's going to be notified, hey, for your ballot to count, you're going to have to provide this documentation, and they'll be able to provide that under the new law. Another big change, and it's yet to be determined sort of how this is going to play out, but the deadline to challenge an absentee voter has been dramatically, in our opinion, dramatically expanded. Now it is 5 business days after election day. So that equates to a week after election day that someone can challenge the counting of someone's absentee ballot. So remains to be seen whether this is going to really tick up how many challenges we see for absentee ballots. It has the possibility of really extending out, county canvass meetings where they have to determine which ballots because whenever there's a challenge, you have to hear that challenge and take evidence. So this could be really something that we have to work through during these elections coming up. Would put in limbo, and however many ballots get challenged they would be put into limbo for that kind of county canvass. So something we're going to be monitoring, but as a pretty big change. Used to be that you had to file that challenge by election day, by 5 p.m. actually. So it's a pretty significant change to the law. We have to now provide daily reporting of absentee ballots. Disregard what I said about SOSO. That's just an internal note for our local election officials. But what this means is that there was an issue in 2020 when a lot of folks wanted to know how many absentee ballots were actually outstanding, because we knew how many had been requested, we knew how many had been sent out, but there wasn't a really great way to determine, oh wait, how many of these people actually went and voted early or on election day, and then automatically spoiled their absentee ballot, because our records would automatically spoil them when they voted. So now we are putting into process that place for the public to have more transparency into how many ballots are really outstanding out there. And then finally, with absentee changes, this only applies to these 10 counties for this election, but there's a pilot program that's going to experiment with matching signatures between an absentee ballot, the voter's absentee ballot, and the records we have of that voter in their voter registration files, using software. So other states do this using software to do this. Traditionally in North Carolina, to verify an absentee voter's identity, we had used the 2 witness requirement. Usually states either do witnesses or signature matching. So the legislature is recommending that we at least try out signature matching as well. There was an effort to require it initially, but that got compromised to a pilot program in the primary. We're supposed to conduct this. It doesn't affect whether these voters votes count, because obviously you can't apply different rules in one county versus another in a state election. But we'll be conducting this pilot to see how the county boards manage this signature matching process after the votes have been tallied. So kind of running it out on an experimental basis, and we'll return those results back in the form of a report back to the legislature about how that program worked. I mentioned limitations on private funds. County boards and the state board cannot accept private funds or in-kind contribution for conducting elections or employing individuals on a temporary basis. So it's very specific prohibition there. We've put out guidance to the county boards on what conducting elections means. There is exceptions in the law for donations of a voting site, like if you had like an Elks Lodge that's willing to donate its site for a voting site, it's not going to require a lease or whatever. Food and beverages for election workers and other sort of inconsequential items like that. So that's a change. I joked in my presentation to the counties, was like, this looks just like your town halls, doesn't it? I got this image from like a stock image search. It must be from some European capital, I don't know. But anyway, I mentioned earlier that there's one change where if you've got municipal elections and the municipality crosses county lines, there used to be confusion in the law who's supposed to certify that election. And so now the law is clear that it's each county that's involved in that election is going to certify the election. It's just the state board is going to combine their abstracts, their results, send it back down to the counties so the counties can issue that certificate of election. And then finally, we've got some changes in our list maintenance practices that start in July. This is the one area of the law that had a later effective date. We are now going to get weekly instead of what we get currently monthly from the state vital records of deaths that get reported up from the registers of deeds, so that we can remove those folks from the voter rolls after we match the data with the voter rolls. It requires weekly felon reporting from our Department of Adult Corrections. Used to be DPS, now Department of Adult Corrections. We already do this on a daily basis, so we're already ahead of this law. And then there is a new requirement to get lists from the local clerks of court on people who get excused from jury service because they say they're not a citizen. So we would do a similar matching against the voter rolls to see if anybody hits on a registered voter. That gets sent down to the county board of elections, and they would there's a process for them to notify the person, say that they're going to be removed absent objection in a hearing. So those are going to be some changes that come down later. Another law here, 747, 749. So 747 is the omnibus elections bill. 749 is the one that changes how the state and county boards are comprised. It is partially halted right now. But what it would do is change the state board to a 5-member body, which is currently has 3 members of the governor's party, 2 members of the opposing party. So currently 3 Democrats and 2 Republicans. Change that to an 8-member board, and the appointments would be from the partisan leadership of each body of the legislature. So the Senate Pro Tem and the Senate Minority Leader, the House Speaker and the House Minority Leader. Each would get 2 appointments apiece. So the idea is, at least in this current framing, it'd be a partisan split 4-4. Well, I guess it would always be that partisan split 4-4, and then at the county board level, it's currently mirroring the state board with a 3-2 composition, and this would change it to a 2-2 composition, where again those same members of the legislature would be able to appoint not 2 but 1 member apiece. So you would have a 2-2 split among parties. Those boards would be charged, as they currently are, with choosing a chair of the board, and at the state level, but choosing the executive director. Now, if they deadlock on this under the new law, then the legislative leadership, not just the leadership, not the both parties, but the majority leadership would choose who is the chair and who is the executive director of the state board. Emergency powers, there's a provision in our law that provides emergency powers to the executive director. Essentially, this is to address natural disasters that may occur, where you may need to extend voting, or you may need to extend early voting period, or some ways to get absentee ballots. For example, if you've got a hurricane, ice storm, whatever it may be, that power has now been transferred to the state board itself from the executive director. That provision actually is not enjoined. That's why I say it's partially enjoined. That is one provision that's not enjoined. But the rest of it, the sort of composition pieces of it, has been partially enjoined and preliminarily enjoined by a superior court in the case that I've referenced there below. That's going to be heard on summary judgment. So a final judgment is going to be rendered by that is a 3-judge panel of superior court. That's going to be heard on February 28th. So we would anticipate some sort of final ruling on that case sometime in March, April. And we have no doubt that the parties, whoever is not prevailing, will want to appeal it. So this is going to be something we're monitoring and seeing how it's going to go for months to come. Just briefly on the state budget, I've talked to some of y'all about SEAMS. SEAMS is our election management system. And not many people know this, but the state board manages the IT infrastructure that touches on every single election process in every single county across the state. And so it's a system that was built in the 1990s, and we've been keeping it running through duct tape and chewing gum, but it's still running. We did get some funding to overhaul a lot of that system, and so we're in process of doing that. We did get funding from the legislature for a photo ID education campaign and restoring some of the reductions that we saw since the 2020 election. We're still an agency that is in less capacity than it was in 2020, significantly less. So I'm just noting that for everybody's knowledge. I will stop right here for a second. The one thing I wanted to mention that's not really addressed in these slides, because this was intended to be a presentation for county boards of elections who, have already gone through a round of photo ID implementation. So I'll just take a pause right now and just let everybody know. I don't have any slides on this, but you all know there was a court case, a series of court cases that had stopped photo ID from being implemented. It was enacted back in 2018, and there was an injunction against its use in 2019, technically early 2020. But so in the 2020 election, 2021, 2022, we did not have photo ID because of the court cases. Now in 2023, in April, the state Supreme Court reversed a lower court decision that had enjoined the photo ID law. So that gave us to go ahead to say, hey, we've got to now implement photo ID in the municipal elections. Most counties did that. There was a handful of counties that did not have municipal elections last year, but the vast majority did, and they implemented photo ID, asking every voter who came in to provide their photo ID, providing exceptions where the law provides exceptions, And also for absentee voters, as I mentioned before, making sure that they included a copy of their photo ID or claimed an exception and appropriately filled out the exception form. So that's been in effect. It's going into effect even, for many more voters now, because as we all know, municipal election turnout somewhere between 4 and 6% of registered voters. It's somewhat higher for primaries. We'll see how much it is for this primary, but then of course we'll see a balloon in the general election. So really this year is where most of our active voters are going to see the photo ID requirement for the first time. Just plainly laying it out there, the photo ID requirement is that you show an ID that is one of the approved IDs under the law. For most voters, it's going to be their DMV issued ID, their driver's license. Passports will work. Military and veterans IDs work. There's a number of student IDs that have been approved by the State Board of Elections for use during voting as well. All of these have to be a photo IDs. We always call it photo ID so that voters understand that it has to have a photograph, because the purpose of photo ID is to say, oh, okay, you are the person showing up to vote. I can confirm your identity with the ID you're presenting to me. Now, the legislature did provide pretty significant exceptions to that. There are 2 exceptions for a voter who shows up to vote but does not have a qualifying ID. It could either be because their IDs expired for too long, or they don't have an ID, and which exists out there. I mean, it's hard for a lot of us to imagine, but everybody's entitled to vote, even if they're on the margins of society. So for those who don't have ID, there are 2 options essentially. One is they can vote with a provisional ballot. And if they're able to obtain an ID or go retrieve the ID if they have one and just forgot it, they can go to their county board of elections before county canvass. County canvass is 10 days after an election, so the voter has until 9 days after election to go to their county board office to show their ID, and then we essentially cure the lack of ID when they voted, and their provisional ballot will count. The second option is for the voter to claim an exception to photo ID. And there are pretty broad exceptions to photo ID that are written into law. There are 3 of them. One is you have a religious objection to being photographed. 2 is you are a victim of a recent official natural disaster, so declared by the governor of the president. Or the broadest one, which is you have a reasonable impediment to showing ID. The reasonable impediment exception was modeled after South Carolina's ID exception law, and so we've sort of provided guidance that is consistent with how that law has been carried out in South Carolina as well. So the way that it works is the voter claims in an affidavit, which we call the ID exception form, so that voters, lay people can understand what it is. They fill out the required elements of that affidavit, and then they explain what the reason is for them not being able to show an ID. And though their ballot under the state law, under the photo ID law, is required to be counted unless the county board determines that what they provided on that affidavit is false. So those are the 2 exceptions, and those are how they get addressed in the process. Again, that second exception, like the first, is provisional voting. So it's handled typically in the canvass process after election day when the county boards are meeting. And so that's the photo ID requirement in a nutshell. So I'll try to breeze through real quickly the court cases now, and make sure I leave enough time for presentations. I mean, for questions, excuse me. And
That'd be great, Paul, because there are some questions building up in the chat. So
oh, right. Well, I can't see those, so forgive me, guys.
no worries.
Court
We'll wait
cases.
to the end. Yep.
I mentioned already the court case dealing with same-day registration. These are the 3 court cases in the Middle District of North Carolina that are addressing various provisions in 747. Same-day registration has been taking up the brunt of the litigation, but there are other things that have been challenged. Here are 4 cases challenging redistricting. So there's more limited one in the Eastern District of North Carolina about some state Senate districts in the East. And then the remainder are broader challenges to redistricting. The only one that has gotten to the decision is that first one. The judge in the Eastern District denied a preliminary injunction that the plaintiffs had sought to halt some of these districts going forward in the primary. That's actually now been appealed to the 4th Circuit. And then the other cases are sort of in their infancy, and no major developments yet. There is also a challenge to North Carolina's residency duration requirement, which means, when you register to vote, you have to have been a resident in your precinct and county for 30 days prior to election day. So another challenge to one of our voter qualifications. And then finally, we have the photo ID lawsuit, the one photo ID lawsuit that is remaining. As I mentioned earlier, the state one was decided by the state Supreme Court. But in the meantime, we've had a federal case that's been kind of on ice for a few years while the state case had moved forward. Now that's moving forward. We've literally yesterday just got notice from the court that we are going to have a trial in May on that photo ID law. So those are the cases of note. Just real quickly, these are sort of inside baseball. I don't need to go into a lot of these. Just issues where the state board has ruled on complaints about county board members, dealing with HAVA Help America Vote Act complaint where there was an issue with our voter registration form that got addressed, and then rulemaking. As I mentioned earlier, the state board has just provided, and the Rules Review Commission approved some rules on observers, dealing with those items that I've mentioned up there. We have that really gets in the weeds, but it's about how proprietary information, the source code of our voting systems, are kept in an escrow account, and state law provides that certain individuals, including representatives of the political parties and counties, can get access to that to review it. And we now have a rule that safeguards that process so that the security of our systems are maintained. As I mentioned, the state board 2 days from now will be voting on the permanent photo ID rules. They put into place temporary rules, and these are sort of administrative rules that are designed to tell the county boards and poll workers how they're supposed to manage the photo ID process, and so that it's a uniform process in every, all of the 100 counties. So the permanent ID rules are going to be drawing on that with some tweaks, but we'll be discussing those at our state board meeting Thursday afternoon. And then just briefly, we do include these resources both for the county board members and staff, and I provide them to you as well. They do have good resources to be able to, especially like things like our law book. I've mentioned to Jennifer and others that we are about to publish a new law book, which is going to be updated with all these new law changes, because if you go to the General Assembly's website, you won't find them there. You'd have to cross-reference the session law and all that. So we are getting an up-to-date election law book, which will be available starting in April, I believe. We have a PDF version already, which I've distributed. We are updating our election law index, where you can look up by topic and find which laws would apply to that topic, and then the other things are sort of self-explanatory. So with that, let me turn it back over to Jennifer and all of you fine people.
Super, Paul. Thanks so much. And if you want to take it off share, we
Sure.
can see you a little better. We really appreciate you taking the time to do this. And as you know, a lot of folks on this commission are hearing some of these things for the first time. Some of them have been working with these for years. A lot of questions about voter ID and list maintenance and voter rolls, as would be expected. So I'll just start from the top of some of the questions that have come in. So somebody wanted to know, how would you know that an absentee voter voted in a manner you would object to? Like, how would somebody even challenge an absentee voter?
Yeah, the most likely scenario would be if you're claiming that voter, maybe you have knowledge that voter died, maybe you have knowledge that voter is serving a felony sentence, maybe you have knowledge that voter has never lived where they're claiming to live. So it's essentially the qualifications of the voter. So it would require you to sort of know something about the voter and make a claim about their eligibility to cast that ballot.
I got
Good
it.
question.
So you'd have to hear them in the bar bragging about, voting illegally or something.
Yeah, right. I mean, it is public record, if somebody's serving a felony sentence. I mean, we get those records and we, purge the rolls based on that. But, it's possible you could have that, or you could have somebody vote early voting and get convicted of a felony 2 days later. So
Exactly. So here's a good question. If a voter has two houses in North Carolina, a summer house and a winter house, how do we know they're not voting in two different counties?
Yes, there's a number of duplicate registration checks that we have in our statewide voter registration system. Ever since the early 2000s, when Congress passed the Help America Vote Act, most states have gone to a computerized voter registration system that is statewide. We did in North Carolina, and what that does is that makes it so that we can cross-reference data from county to county. And when we have this personal identifier information like Social Security's driver's license, you can cross-reference that. You can cross-reference dates of birth with first, last, and middle, and you can get pretty good matches for potential duplicates. And we do that regularly, and the county boards are instructed on a regular basis to use those lists that we create at the state board to pull off duplicate registration, or we call merge duplicate registration role. Yeah.
And I assume there's another question about duplicate names, like if there are, 100 John Smiths, how do you, what kind of secondary information do you use to make sure it's the right person? And I guess
Yeah,
you,
we have to be careful about using matching criteria that's pretty strict. We can't use loose matching criteria that's going to pull in a lot of people who, just share a common name. Or even you can often have times somebody with the same name that lives in the same address. It's a junior and a senior. So you have to be careful about this. You have to use strict matching requirements so you don't fold in people who are eligible voters and remove their registration records.
we heard a fun story once about somebody who did just that, had the same name, was a junior, went to vote. His father had passed away, and he made the mistake of going the second time to vote with his "I voted" sticker on.
Ooh.
But they also can look at age, correct?
Yes, yeah, they can look at age. Yeah, yeah, absolutely.
Yeah,
Um,
he
yeah,
was not allowed to vote twice.
I'm glad to
Um,
hear that.
yeah. Election directors have good stories. Um,
Mhm.
so another question, what is the rationale for changing the early voting tabulation in the past that occurred at 7:30 on election day so that it now takes an hour to get that? What was the rationale behind that?
It wasn't stated clearly and publicly during the debates on 747. The best that we can assume is that there was a worry about, county boards who are politically appointed, county board members knowing certain election results before the polls close. Now, what you could do with that at 2 p.m. on election day is, I don't know. It's beyond me. But I, that's the best we can think of, is maybe there was some lurking suspicion that nobody should essentially know what election results are, any species of election results, until the close of the polls.
I gotcha. There was also a question about the exceptions on the photo ID, and basically our election directors and judges instructed to accept pretty much all those exceptions for people who are unable to provide that photo ID.
Yeah, so the exceptions are in statute. So that they're in that list because they're provided in the statute as permissible exceptions. Now, the only reason that a county board can reject an ID exception is if they find that the voter's affidavit is false. And the state board has promulgated an administrative rule that requires that to be unanimous, so that it is a bipartisan finding and not just a party-oriented finding. So it can happen. It has happened in the municipal elections. It predominantly happens when someone claims something that is not actually an impediment to showing an ID. For example, I don't believe in this law. Well, that may not be false, but it's false that is an actual impediment to you presenting ID. That doesn't keep you from presenting ID. So county boards have found that is a false statement about whether that's preventing you from showing ID. That's really just a personal opinion on the law. But yeah, they can and do, if they have reason to believe and grounds to believe that there is a falsity on the affidavit. I mean, that's the more likely scenario that I just talked about. You know, if someone says, I lack transportation, then they would really have to have some sort of, extrinsic evidence to be able to come into that determination that, they're not being truthful on the form, that they, maybe I know that person and they have 3 cars. I don't know what it is. You'd have to have some additional evidence to go into that finding. Yeah.
So Shawnee, who is one of our commissioners, said I didn't quite get the question correct. So Shawnee, if you want to unmute and ask exactly what you're asking about, the 150 acceptable forms. Can you unmute?
Yes,
Yeah.
yes. Thank you. Thank you so
Sure.
much. This has been so wonderful and I appreciate your time. My concern has been the photo IDs and the over 150 acceptable IDs that are coming from different agencies across the state, whether they're schools or, human service agencies or whatever. And I'm concerned that these different agencies will provide an ID to people, but are the requirements to have that ID provided to a person the same across the board to protect our elections? Because anybody could go to any one of those agencies, get an ID, and then all of a sudden it's acceptable when we can't really prove. Maybe they are not required to prove residency, or maybe they're not required to prove citizenship, or you know uh, I just, it's 150 IDs is kind of, in my opinion, it breaks the chain of custody.
Well, two things to say about that. One is that, the ID requirement is proving your identity. It's not proving your qualifications to vote. So
Right.
whenever you're registered to vote, there's a process to prove your residence. And so the ID is intent, it's statutory intent, it's placed in the statute. The idea is to confirm that the first person presenting to vote is the person that they claim to be. Now, you raised the question about a number of IDs that have been provided. Now, the legislature provided a process for student and government employee IDs to be approved. There hasn't been, I mean, you mentioned service agencies. Honestly, there is a provision in the law that allows for public assistance IDs.
Yes.
We've not located any example in the universe in North Carolina or in federal public assistance of an agency that provides an ID to a client that also includes a photo. So we have no example of that ID actually existing. So the 150 IDs you're talking about, it's actually closer to 100, but the 100 IDs you're talking about are student IDs that went through an approval process that had statutory criteria for how they secure the ID issuance process. It's public agency employee IDs that go through a statutory process for securing those ID issuance. So I do think that the legislature did a pretty good job of keeping that a fairly secure process, and we have no indication that schools or governmental employees or employers are abusing that process.
Well, I'm just asking because, a lot of our grants that had come through during the pandemic, there's big questions regarding the DACA students, things like that, that would prevent them, to receive certain federal benefits. And so my thinking is, okay, so we have a bunch of migrants that are coming over. They're needing services. They're going to be entering schools because schools are going to be allowed to take them as well. They'll be able to get those IDs showing their, a photo ID. How are we ensuring that our elections are not allowing people that are not eligible to truly vote in our elections that they're going to be able to bypass that and vote?
Yeah, so I'll go back to my original point, which is the idea is not proving your qualifications as a voter under the state statutory constitutional qualifications to vote. It's proving you are the person you claim to be. So anybody who registers to vote has to attest under penalty of perjury that they're a U.S. citizen. They provide personal identifying documents, identifying numbers such as the last four of your social security number or your driver's license number, which is matched against official databases to confirm identity. So, and then when they show up to vote in person, they're confronted again with stark language saying it is a felony for you to vote while claiming you're eligible when you're not. So those are the checks on the process. The photo ID is there to confirm that the person is who they claim to be.
And then lastly, to follow up with that, what are the county boards able to do? What would be the proper steps for county boards to handle a situation where they really did question the acceptable ID of a person?
So the county board, if the ID is not an acceptable type of ID under the law, then they would just reject it. And they say,
Okay.
you cannot use this Sam's Club card. And say, you're going to have to provide one of these acceptable types of ID. Alternatively, if they provide an ID and it looks nothing like them, then the check-in official is instructed to challenge that voter, and the judges of elections have to hear that challenge right then and there at the voting site and determine whether they're going to allow that ID to be used to confirm that person's identity.
Okay. Well, that's great. Thank you so much.
Yeah, thanks, Shawnee. And, these are the kind of questions that we are going to have a lot of people wondering about because voter ID is new. And thanks for making that important distinction between identifying who you are versus the registering to vote in that process, and things that are checked to make sure you are, that you are eligible to vote. There was another question that came in about unaffiliated voters and whether there's been any movement on. I know that a lot of unaffiliated voters feel kind of left out because they can't be observers, they can't serve on boards of election. Has there been anything that's changed in the law or anything pending with relation to unaffiliated voters from that perspective?
Well, I mean, the Senate Bill 749 would technically allow anyone, regardless of affiliation, to be appointed. I mean, in practice, I don't know how many unaffiliated voters will get appointed by the political leaders of the General Assembly. Remains to be seen. But yeah, it's under law now that in the pre-existing law that you would have to be a registrant of one of those parties to be chosen. The one exception is the chair of the county boards of elections. The governor can choose someone of unaffiliated status to be there. It doesn't have to have an affiliation with a particular party. Now, in terms of being an observer, again, yeah, technically you don't have to be registered with a political party to be an observer for that political party. Now, how many political parties are going to offer up an unaffiliated observer is it's sort of an academic question, but yeah, I there's not the laws haven't really changed in that regard. I think the purpose behind this is to sort of get both sides of the political spectrum, or both sides that are vying for votes, to have a buy-in and participation in the conduct of the election. And that's why we have bipartisan representation on the boards of elections, why we have bipartisan representation in the voting site with judges and chief judges and observers. There are debates to be had about whether that's the best approach and whether you should involve unaffiliated voters more. Yeah, that's the system we live with now.
Terrific. Well, we have about 3 minutes left in our hour. I know some folks have had to drop off, but there aren't, I don't think I missed any of the questions in the chat. If I did, whoever, or if anybody has another question, you are free to unmute and ask that. But I want to first just say thank you so much, Paul. We are going to have this recording and your slides on the shared drive for the Election Commission. So if anybody saw those slides go by too fast, you want to go and listen to it again, you are more than welcome to do that. But is there any last question before we close out?
Can I ask one?
Sure, go ahead, Susan.
Okay, I would just be interested to know, were these changes mostly brought about by legislators or by the state board? Were they something the state board asked to be changed or not?
Predominantly, no. Predominantly, the changes were policy initiatives of the legislature.
Okay.
There were some that we had requested, such as I
Right.
mentioned that 7 versus 10 week second primary. We had requested some revisions to the Electoral Count Act for the Electoral College just to comply with federal law. We had requested that the absentee deficiency cure process be codified just so that it's in the law. But by and large, everything else was stuff that was policy initiatives of the legislature.
Okay, I was just interested in, and also the signature matching pilot program, the 10 counties that were chosen, how were they chosen? Is there any particular reason? Mine's
Yes.
one, that's why I was curious.
Oh, lucky y'all. So there was a provision in the session law said that we had to choose essentially diversity of geography and demographics, and the state board went through a process of sort of making sure that it had representation using a semi random drawing process where you sort of categorized counties based upon demographics, population size, region, and they selected these at random based upon those categorizations, and then came up with those 10.
I was just curious, but I just want to say this has been fascinating. It's been a wonderful hour, and thank you for giving us your time. It really was so interesting. Thank you.
Thank you for saying that.
Awesome. So we're at the end. Bob, or are you still on?
I
Did you want-
am, and I would just say I am repeatedly stunned at the complexity of the issues that Paul and the staff at the state board have to grapple with. I know they're understaffed, and we appreciate enormously not just you talking to us, but just the work you do for the entire state.
Thank you for saying that, Bob. Appreciate it.
Awesome. All right. Well, I think it's a wrap. And if you have questions that weren't answered, Paul is great at answering things on email. And we wish you luck as early voting starts.
That's right.
Let's have a safe and secure and happy primary.
Absolutely. I'll second that. And thank you all.
Right.
Thank you, Bob. Thank you, buddy.
Thanks, everybody.